Hi, welcome back. In this session, we are going to discuss about some of the common legal maxims. So the first one, actio personalis morita cum persona. It means a personal right of action dies with the person. The general rule is that if a person dies, the right of the action also dies with him. The common law recognizes one exception, that is, the right of action can be fulfilled by the legal representatives of the deceased. That means the right to sue will survive. Now, actus non facit rem nisi menset rea. So, this is very important with respect to IPC. Actus non facit rem nisi menset rea. It means that an act does not become a crime unless done with a guilty mind. That is, an act itself does not constitute guilt unless done with a guilty intention. This is the basic principle of criminal jurisprudence. In order to constitute a crime, there should be two elements. The main elements of the crime are actus rea, that is a physical act, and mens rea, that is the mental intention. Now, odi alteram partem. It is a part of natural justice principle. It means here the other side. This is the basic principle of natural justice. The authority must take decision only after hearing both the sides. The authority should be given a responsible opportunity to defend him. This is also known as rule of fair hearing. The essential of rule of fair hearing are: 1. Proper notice must be served to the parties. The second, opportunity of the producing evidence must be given. The third, opportunity for cross-examination must be given. And the fourth, right to be represented by a lawyer. So that is basic of fair hearing. De minimis non curat lex. It means law does not deal with trifles. That means law will not deal with minor things. It is the defense under Indian Penal Code. For example, taking a pin without the consent of the owner is not an offense because it is a trifle. Or using the import of another person, such are trifles and they are not crimes. And the next one, ex nudo pacto non oritur actio. It means no cause of action arises from a bare promise or an agreement. It is the basic principle of Contract Act. It is an essential ingredient of a valid contract. An agreement without consideration is void. Consideration means something in return. Section 2 Clause D of the Indian Contract Act deals with the term consideration. It is an unavoidable part of the contract. So that is ex nudo pacto non oritur actio. Means no course of action arises from a bare promise or an agreement. Then ex turpi causa non oritur actio. Ex turpi causa non oritur actio. It means an action does not arise from a bare cause. That means no cause of action arises from an immoral act. Immoral agreements cannot be enforced through court of law. This is the basic principle under the Indian Contract Act. Now, falsus in uno, falsus in omnibus. Falsus in uno, falsus in omnibus. It means false in one particular is false in general. This rule is applicable in England, but it is having no application in India. As per this rule, statement given by a witness is found to be false, his entire statement must be false. Example, A is a witness, he gives us false statement. 5 statements. One statement is found to be false, then the entire statements will be declared as false. That is applicable in England but not in India. That is falsus in uno, falsus in omnibus. Now, Fiat justitia ruet coelum. Fiat justitia ruet coelum. It means justice shall be done even if the heavens fall down. The ultimate aim of court is the administration of justice. It must be implemented even if the heaven fall down. Then, generalia specialibus non derogant. Generalia specialibus non derogant. It means general things do not derogate from special things. That is, general things does not derive from special things. So when there is a special statute and the general statute, the special statute will be given priority or prominence. Ignorantia facti excusat, ignorantia juris non excusat. It means ignorance of fact is excusable, but ignorance of law is not excusable. That is, ignorance of fact is excusable one, but one that of law is not. The legal presumption is that everyone is fully aware about the law. It's a presumption, so it is held valid. Irrebuttable presumption. Ignorance of law is not a way to escape an offender from liability. So, ignorantia facti excusat, ignorantia juris non excusat. Then, lex injustitis non est lex. It means unjust laws are not laws. It is an important principle in the administration of justice. If any provision which violate the fundamental rights, that is treated as unjust law. Now, nemo dat quod non habet. Nemo dat quod non habet. It means no one can convey a better title than what he himself has. This is a basic principle under the Indian Contract Act. The transferor should have a valid title to the transfer or authority to transfer it. Nemo judex in causa sua. This is again a basic principle in natural justice principle. Nemo judex in causa sua. It means no one shall be made the judge of his own cause. This is the basic principle of natural justice. It is called rule against bias. Example, father is the judge, son is the plaintiff. So there is a bias. Now, novus actus interveniens. Novus actus interveniens. It means a new act intervening. This is the defense available to the defendant. Then, Q facit per alium facit per se. Qui facit per alium facit per se. It means he who does an act through another does it himself. This is the basic principle of vicarious liability. Act done by one person, but the liability goes to another person. It is applicable only in civil matters. It is not applicable in the case of crime. Then, respondent superior. It means let the principal be liable. Any act done by the servants or agent during the course of employment, the master will be liable. It is the basic principle of vicarious liability. It is applicable only in civil matters. Then, res ipsa locator. Res ipsa locator. It means the things speak for it. It is the prima facie evidence of negligence. Then, nulla poena sine lege. Nulla poena sine lege. It means no punishment except in accordance with law. That means punishment is given only with the support of law or based on authority of law. In order to impose criminal liability, it must be an offense in existing law. Then, Ubi jus ibi remedium. Ubi jus ibi remedium. It means every right has a remedy. That is, whenever there is a right, there is a remedy. If a person has a right, definitely there will be remedy for its breach. Then, voluntary non-fit injuria. It means damages suffered by consent is not a cause of action. That is, after giving consent, one cannot complain. Then, nemo debet bis vexari pro una et idem causa. Nemo debet bis vexari pro una et idem causa. It means that no one shall be vexed twice for the same cause. It expresses a fundamental rule of criminal law which prevents jeopardy, double jeopardy. Then, nemo debet esse judex in propria sua cosa. Nemo debet esse judex in propria sua cosa. It means no man can be judged in his own cause. So that is the same as nemo judex in causa sua. So nemo debet esse judex in propria sua cosa. It is a basic principle of implementing of justice. The basic concept behind the principle is that the judge is having any connection with regard to the case, such judge shall not proceed with the case. So that is with this session. I hope it was helpful. If you like it, please click the like button. If you haven't subscribed, please subscribe. If you have any feedback, please drop it in the comment. Thank you for your support. Have a nice day.